To make the best use of the session, I suggest you do two things. Number one, go through my theory session on legal reasoning. The link to the session is given on the description below. Second, create a free sign-up account on our website and solve the exercise on your own before you go through the video. The process for the free sign-up is also given on the description below. Now that you would have done both the things, let's start the class. Hello students, welcome to another practice session on legal reasoning with me. Today we'll discuss the passage 3 which was issued by CLAT Consortium in the sample paper. Okay. So assuming that you would have gone through the passage on your own on our portal, on our website, and attempted it in a test format, I'll come directly to the explanation of the passage. So if comparing this with the first passage, you'll see there are not many principles. In fact, there is only one principle. So the doctrine which is spoken of is doctrine of privity of contract. Okay. So in a case of Bina versus Karuti Car Company, what happened? So there was a second-hand buyer of the car. So Karuti, as a car company, did not have a contract directly with the second-hand car owner. The Karuti Car Company would have had a contract with the first time the new car customer. But the court ordered that the car is liable for any damage incurred even by the second-hand car owner. So principle of law of privity of contract says that if you are a third party to a contract, you cannot be conferred a right, nor can you be made liable for certain obligations. So basically ये है कि अगर आप third party हो contract का, तो ना तो आपको right दिया जा सकता है, ना आपके ऊपर कोई obligation हो सकती है. Which means as a third party you cannot sue, you cannot enforce the contract. Obviously there are certain exceptions to law of privity of contract, but इस passage में exceptions की बात नहीं करी है. इस passage में बोला है कि ये doctrine of privity of contract थी, जो इस case में was not applied because this second-hand car owner did not have a contract with Karuti Car Company, but the court said that the car is still liable to pay. Okay. Now what happened? Sometime later, the case of Sabu versus Digistan, the same thing happened, which is in that case, the consumer Sabu, a patron at the Welcome Cafe in Mangalore, was with a companion who ordered a soft drink. Sabu drank about half a glass of a soft drink, and then the proprietor of the cafe refilled the glass with the opaque bottle. Dead snail tumbled into Sabu's glass. The sight and smell of the decomposed snail caused Sabu gastric distress and mental shock, and she sued the manufacturer. So if you look at this one, you might think that there's no direct contract between the manufacturer and Sabu. Contract to Sabu और जो patron जो cafe का है, Welcome Cafe, उसके बीच में है contract because Sabu is interacting with the Welcome Cafe guy. So there is no, with the manufacturer, there is no direct contract. So privity of contract के हिसाब से Sabu cannot sue the manufacturer because there is no direct contract. However, okay, let's look at this. So being this the case, Sabu के lawyer ने बोला क्या? Sabu lawyer said he cited the case of Bina versus Karuti Car Company. In that case also, company or the party जिसका जो victim था उस party case में did not have a direct contract. Right, so वहां पे भी privity of contract को avoid करा था. So the same thing the lawyer is saying here, that same principle applies here. Okay, even though there was no contract between her and Kyrgyzstan. Now this thing comes into the picture, the rule of precedent. मतलब अगर पहले जो हुआ है same चीज वो दोबारा करेंगे, तो वही rule जो उस time लगा था, same rule will apply here. Okay, provides that a court must follow its own previous decision in cases that are similar to the cases that resulted in such previous decisions, but not in cases that are different from the cases as compared to previous decisions. So there is only one principle, guys, in this passage, which is rule of precedent तभी लगेगा अगर आज का जो case है that is similar to the previous case. So if you have to prove, let's say if I am the aggrieved party, मुझे damage चाहिए, and I want the rule of precedent, which is आप doctrine of privity को avoid करो. So how can I do this? How can I get the court to decide in my favor? All I have to prove is that my case is similar to the case of Bina versus Karuti Car Company. ऑन द अदर हैंड जो दूसरी पार्टी है जिसको डैमेज से बचना है, टू अवॉइड दिस व्हाट द अदर पार्टी विल हैव टू प्रूव कि द केस इन दिस द सिचुएशन इन दिस केस is not or are not similar to the situation in Bina versus Karuti Car Company. एक ही criteria है decision that the case are similar to the case in the previous one situation. ठीक है? So not many rules. एक doctrine of privity given है, which is if you're a third party, you can't enforce a contract. However, in Bina versus Karuti case, doctrine of privity को deny कर दिया था. अब when all can you apply this Bina versus Karuti case? Basically, rule of precedent आप कब लगा सकते हो? It will apply if you can prove that the cases are similar, the situation is similar. It will not apply if you can prove that the case is not similar. So this is what has happened. In Bina versus Karuti case, कौन से parties थी guys? Party 1, Karuti Car Company. There was new car customer who bought it for the first time. Then there was a contract between these two. There's a contract, direct contract between these two, direct contract between these two, and direct contract between these two. तो अगर पार्टी टू द कॉन्ट्रैक्ट आप देखें तो न्यू कार कस्टमर एंड सेकेंड हैंड कस्टमर होगा, कारुति कार कंपनी एंड न्यू कार कंपनी एंड कारुति कार कंपनी एंड व्हील सप्लायर. तो इसका और इसका there was no direct contract, so ideally this party, if you were to apply the doctrine of privity of contract, should not be able to sue this company. But is Bina versus Karuti case में court said कि no, the Karuti car is still liable, and it said the doctrine of privity of contract does not apply. अब ये वाला principle कब apply होगा? When you prove that the cases were similar. So this is what has happened in the passage. Let's come to question number 1. Based on the information in the given passage, which of the following, if correct, would strengthen Dinkistan's case? ठीक है, Dinkistan कौन है? The soft drink company. So if it has to strengthen its case, there is only one principle, which is it has to prove our case is not similar to the Karuti car case. That's it. As per the passage, no other principle you have to apply, because there is only one principle. Look at option number A. Since the Karuti car company case involved cars which are inherently more dangerous and likely to cause more harm than soft drinks, which means the cases are different. Comparison with car and soft drink, the cases are different. If this is true, if this is correct, then Drinkistan company can avoid the rule of precedent, and therefore this is the correct answer. If you look at option B, our car manufacturer has a duty of care towards the customers and so should manufacture all the parts of the car itself. What about the soft drink? उसके बारे में तो बताया नहीं भी, वो भी उसकी भी ड्यूटी हो सकती है. So that's why this is out. Okay. Regardless of whether the transaction leading to the harm occurred in Guwahati or Mangalore, the underlying principle in both cases is the same. See, this one is weakening Dinkistan case. ये साबू के फेवर की बात कर रहा है, Dinkistan के फेवर की बात नहीं कर रहा है. So this is out, and D is also out. In any question that I discuss, guys, if you strongly think that some other choice should have been a correct answer, you can put it in the description, and I discuss why that is not the correct answer. Okay. Look at 3.2. Based on the information in the given passage, which of the following, if correct, would most strengthen Sabu's case? Sabu के case को strengthen करना है. So to strengthen the Sabu case, there is only one principle. You have to prove that the case in this case is similar, situation is similar to आपका कारुति कार case. ठीक है, देखो. Cannot be ignored. हो सकता है, let's keep it for a while, but इसमें similar situation वाली बात नहीं आई. Look at B. Since Guwahati is a very different place, two cases are dissimilar. If the cases are dissimilar, it will not help Sabu. So this is out. Look at C. So obviously, because B cannot be the answer, even D cannot be the answer. So my answer has to be A or C. The rule of precedent would apply in the present case, and the Supreme Court should ignore the doctrine of privity of the case as well, since the manufacturer owes a duty of care towards the eventual uses of the product. So a manufacturer of a product, any product, be it car, be it salt, be it soft drink, owes a duty of care. So case similar hai. If you are a manufacturer, your duty is same, which means case is similar. Therefore, C is a better answer than A. Let's come to 3.3. Okay. Sabu buys a car directly from the Karuti car company and later replaces the brakes in the car with a set of brakes she had purchased from other manufacturer. ठीक है, एक बार क्विकली आप पढ़ लो. The car is later involved in an accident and Sabu suffers some injury because of the brakes in the car that did not work. Sabu sues Karuti Car Company claiming that the rule of precedent should apply and she should be awarded damages just as in Bina's case. Which of the following would be the correct result? So सबसे पहले guys decide, is he eligible for damage? क्या उसे damage मिलना चाहिए? Yes or no? ठीक है. Is the case similar? So सबसे पहले it would not apply, case similar नहीं है. उसने change करा with a material part of some other manufacturer, not which was not engaged with Karuti Car. So would apply तो नहीं होगा guys. The answer is would not apply, would not apply. Now look at the explanation. Cases have to be different. That has to come out. Since Sabu had purchased the car directly from Karuti and therefore this case is different from Bina's case. Since Sabu had purchased the car directly from, that does not make any difference. Rule of privity वही होता है. किसी से भी खरीदो, case similar होना चाहिए. Two different cases. Okay. The rule of precedent would not apply in this case. Since Sabu had replaced the brake herself, this case is different from Bina's case and Sabu would not be awarded damages. Yes. Right? How is this case different from C? Because you are changing a material part which is not provided by the manufacturer जिससे आप खरीद रहे हो. तो इसका case उससे different है. Therefore, D is the correct answer. C is not. Okay. Assume the following are all valid principles of Indian law. Which of this would result in a decision in the Karuti case not being applied to Drinkinstan case? So Karuti case में doctrine of privity was denied. So Drinkinstan case में it should be applicable. तभी वो result same नहीं होगा, right? Regardless of the extent of danger a product can cause, the manufacturer owes a reasonable duty to the care to the consumer. So if this is a valid principle, guys, तो दोनों ही केस में मैन्युफैक्चरर को देना पड़ेगा डैमेज. सो ड्रिंकिस्तान के क्वेश्चन सेज इट शुड अप्लाई टू कारुति but it should not apply to Drinkinstan. If A is a valid principle, it will apply to both. So this is not the correct answer. Even though a manufacturer owes a duty of care to the customer, even the person who finally sells the product of the consumer owes a consumer of duty to care. So in this case, वहां पे कारुति में manufacturer was responsible. In this case, the soft drink will also be responsible. Option B की वजह से क्या हो रहा है? Third party की responsibility भी आ रही है, but it is not taking away the responsibility of the manufacturer. So in both the cases, कारुति केस में जो डिसीजन हुआ है वो ड्रिंकिस्तान में भी होगा. इसमें जो थर्ड पार्टी है जो बीच में उसकी रिस्पॉन्सिबिलिटी भी आ जाती है. So this is not the answer. C. Matters such as mental distress, though hard to diagnose, do constitute sufficient ground for award for damages. So again, C is also saying कि ड्रिंकिस्तान केस में भी डैमेज मिलना चाहिए. कारुति में मिला था, यहां पे भी मिलना चाहिए. आंसर क्या आना चाहिए? कारुति में मिला है, यहां नहीं मिलेगा. So none of the choices is leading us to a conclusion that जो कारुति में दिया है वो ड्रिंकिस्तान में नहीं देना चाहिए. तीनों ही केस में ड्रिंकिस्तान में भी डैमेज देना पड़ेगा. Therefore the answer is D. Right? Answer is D. All right. Last question of the passage. Based on the description of the rule of precedent set out in the given passage, which of the following is likely to be a result of the application of the rule? Courts would award higher damages? नहीं. ठीक है, सेम होता है, higher तो नहीं बोला है. Courts would treat people who are in similar situation in similar fashion? Yes, this is the correct answer. Higher lesser नहीं है, ये कोई भी नहीं है. It's the same. Similar situation, two different cases, similar situation, same rule will apply. That means same damage would be awarded. So the answer is B. All right. Great, guys. So this passage is also discussed. As I've told you, I would be discussing, I think, minimum 25 passages with you. The best way to make use of these passages is go to our portal, create a free sign up account. The description is given in the link below on our description. The link is given on the description. Create your own sign up account, practice this in a form of test, and then come and have a look at the video, right? Also, test series, extremely important, guys. The more the number of mocks you write, the higher chances of clearing the exam is. But the test series has to be relevant. We have invested a lot of time in coming up with a good test series. Again, in a sign up account, we have given you a free test, free full and mock test. Attempt it. and see the difference and the quality of a mock. And yes, and I'm sure you would like to practice with us. Remember, coaching kahin se bhi, test series has to be from Mentors Capital. Thank you.